In this lecture, we would like to discuss constitutional commissions. As we know, there are number of commissions constituted by the legislature, also by the executive, and as we know, those commissions which are constituted by the union legislature or the state legislature as per the provisions of any act enacted by the legislature, all those commissions could be called as statutory commissions. So the commissions constituted by the executive organs of the state or government. So besides that, we found there are certain commissions which could found place in the Constitution of India, and among such constitutions which found placed in the Constitution of India, the first one that we would like to discuss, the National Judicial Appointment Commission, as provided under Article 124A, Article 124B, and Article 124C, which are inserted under the 99th Amendment Act of 2014. So, as per the provisions of Article 124A, Clause 1, there shall be a commission to be known as the National Judicial Appointments Commission, and the very commission would constitute consisting the Chief Justice of India as the chairperson ex officio, also two other senior judges of the Supreme Court next to the Chief Justice of India as members ex officio, also the Union Minister in charge of law and justice as member ex officio, and so also two eminent persons to be nominated by the committee consisting of the Prime Minister, the Chief Justice of India, and the leader of opposition in the House of the People or Lok Sabha, or where there is no such leader of opposition, then the leader of the single largest opposition party in the House of People as members into the National Judicial Appointment Commission. So, provided that one of the eminent persons shall be nominated from among the persons belonging to the scheduled caste, the scheduled tribes, or other backward classes, minorities, or women. So, this would be the constitution and formation of the National Judicial Appointments Commission as per the provisions of Article 124A inserted as under 99th Amendment Act 2004. So also, Article 2 124B provides about The function of the very commission constituted under Article 124A as National Judicial Appointments Commission. So the very function or duty of this commission would be to recommend persons for appointments as Chief Justice of India, judges of the Supreme Court, Chief Justices of High Courts and other judges of High Courts. So also it would recommend transfer of Chief Justices and other judges of High Court from one High Court to any other High Court, and also it would ensure that the person recommended is of ability and integrity, and as per the provisions of Article 124 C, it relating to the power of Parliament to make law regarding National Judicial Appointments Commission. So the Parliament may by law regulate the procedure for the appointment of Chief Justice of India and other judges of the Supreme Court and Chief Justices and other judges of High Court, and empower the Commission to lay down by regulation the procedure for discharge of its functions, the manner of selection of persons for appointment, and such other matters as may be considered necessary by it. So, the newly inserted articles such as Article 124A, Article 124B clearly provides the very constitution and establishment of National Judicial Appointments Commission. So also the very functions of the commission, and as regarding Article 124C, all the powers in relation to appointments of Chief Justice and judges of Supreme Court and Chief Justices of High Courts and judges of High Court, and the functions of this National Judicial Appointments Commission. The Parliament is the supreme authority to legislate it, to make any law, and in regards to that we would like to discuss one important leading case, and that is relating to Advocates on Record Association versus Union of India in 2016, where it was pronounced by the Supreme Court in relation to the appointment of Supreme Court judges and the Chief Justice of India. So, in relation to that, as we found that in connection to appointment of Supreme Court and judges of High Court, it was laid down in this important leading case that the judges and the Chief Justice of India, as per the provisions of Article 124A of the Constitution, and as regarding Article 124B, and also as relating to Article 124B, the very amendment and creation of National Judicial Appointment Commission was declared as null and void, and the Supreme Court resorted to the previous collegium system, which is selecting and recommending persons of ability and integrity to be appointed as Chief Justices of High Courts and judges of High Courts also, the Chief Justice of India and the judges of the Supreme Court, as it was followed since the period that the Constitution commenced in 1950. So they, the learned Supreme Court judges, they upheld the traditional collegium system of selecting and recommending the names for appointment of judges of Supreme Court and Chief Justice of India, so also Chief Justice of different high courts, and so also judges of different high courts. And now we'll discuss another important constitutional commission is the Finance Commission as provided under Article 280 and 281, and as per the provisions of insertment of class 3 subclass double B and subclass C and D as per 74th Amendment Act of 1992 and also the 74th Constitutional Amendment Act 1992. So, in relation to that, would like to discuss the Finance Commission of India, and which is a constitutional commission as it is found place in the constitutional document, and it is an original part of the Constitution of India. So, as per the provisions of Article 280, the President shall within 2 years from the commencement of this Constitution and thereafter, at the expiration of every 5th year, or at such earlier time as the President considers necessary by order, constitute a Finance Commission, which shall consist of a chairman and 4 other members to be appointed by the President. Also, under Class 2, Parliament may by law determine the qualifications which shall be requisite for appointment as members of the Commission, and the manner in which they shall be selected. And Clause 3 provides that it shall be the duty of the Commission to make recommendations to the President as regarding distribution between Union and States of the net proceeds of taxes, which are to be or may be divided between them under this chapter, and the allocation between the states of the respective shares of such proceeds. Also, the principles which should govern the grant in aid of revenues of the states out of the Consolidated Fund of India. So also, as per the 73rd Amendment Act 1992, as in addition clause 3 to sharp clauses double B, the measures needed to augment the consolidated fund of the state in supplement to resources of the panchayats in the state on the basis of the recommendations made by the Finance Commission of a state. So, also, as per the inserted provisions under subclauses C and D, we found the measures needed to augment the consolidated fund of a state to supplement the resources of the municipalities in the state on the basis of the recommendations made by the Finance Commission of the state. So, another important insertment as under Clause D as per the 74th Amendment Act 1992. Any other matter referred to the Commission by the President in the interest of sound finance. So, also under Clause 4 of Article 280 relating to Finance Commission, we found the Commission shall determine their procedure and shall have such powers in the performance of their functions as Parliament may by law confer on them. And now we'll discuss the provisions as provided under Article 281 relating to the recommendations of the Finance Commission. The President shall cause every recommendation made by the Finance Commission under the provision of this Constitution together with an explanatory memorandum as to the action taken thereon to be laid before each House of Parliament. So, the Articles 280 and Article 281 of the Constitution is relating to the very constitution and establishment of Finance Commission, its powers and functions, also the very recommendations of the Finance Commission to be placed by the President of India before each House of Parliament as provided under Article 281 of the Constitution. So, in this lecture, we have discussed two important constitutional commission which found place in the constitutional document, that is the Constitution of India, as the National Judicial Appointments Commission, as provided under Article 124A, 124B, and Article 124C, as per the 99th Constitutional Amendment Act of 2014. And in that connection, we have discussed the leading case, Advocates and Record Association versus Union of India in 2016, in which the judgment of Supreme Court rejected and declared invalid on the National Judicial Appointments Commission. Instead, they in favor retaining the old collegium system of selecting and recommending the names of persons suitable to be appointed as judges of Supreme Court, judges of High Court, Chief Justices of High Court, and the Chief Justice of India. And also we have discussed another important constitutional commission which found place in the very document of the Constitution of India, which came into effect in 1950, January 26, that is the Finance Commission. And in relation to that, we discussed the provisions of Article 280 and Article 281, and also the two most important amendments as 73rd Amendment Act 1992, which made allocation of resources from the Consolidated Fund of a state to the Panchayat to supplement their resources, and 74th Amendment Act 1992 also relates to allocation of resources to municipalities out of the consolidated fund of a state. And in our next upcoming video, we would like to discuss some other important constitutional commissions such as public service commissions and also election commission